Well, I'm all for Christmas, all the happy smiles and the wishes, and I want it all from the lights to the mistletoe. Tell me one thing, is there anything that you're missing? I will keep you warm as soon as you remove that snow. Whatever we do, we will be alright. These holiday wonders will open your mind. May all your wishes tonight come true. The love I lived, the dream I knew. This Christmas I only wanna be close to you. Whatever we do, we will be alright. These holiday wonders will open your mind. May all your wishes tonight come true. The love I lived, the dream I knew. Well, I'm all for Christmas. It's a magical time full of kisses. Take a walk outside and tickle the snowman's nose. Moving nimbly, did you hear something from the chimney? I will keep you warm as soon as you remove that snow. Oh, whatever we do, we will be alright. These holiday wonders will open your mind. May all your wishes tonight come true. The love I lived, the dream I knew. This Christmas, I only wanna be close to you.
Oh, that's so special. I want to play y'all some Christmas music. Hello, Brooksaholics. How are you, you little weirdos? John Bubba's still looking for that subject matter jurisdiction. Mine's underneath my Christmas tree. Lori says, I'm a grown woman and I got grown kids. Ain't nobody gonna tell me what to do. I got a couple of starred things here I want to talk about. First of all, let's talk about the sandwich, Debbie. Debbie, did you really talk to Daniel? Or are you being funny? Because if you did, we all need to know. Like the jury, we deserve to know. We need to know. It was a ham sandwich. And all this time, we thought it was tuna. There you go, guys. Brenda says, is this the day? This is the day when DB almost loses his finger due to, oh, yeah, due to the brutality of the bailiffs, right? Right? Yeah, right. Linda, welcome back to the Hee Hee and the Kiki Club. You let your membership expire. You probably got a gifted membership, maybe, Linda, and it expired, and you didn't know it. That might have been what happened. All Mark wants for Christmas is subject matter jurisdiction. Warren says, War and Peace. That's so cute, War and Peace. War and Peace, just rewatching this, but hey, this is going to be special. Don't you know it? You know why it's special? Because of y'all. Y'all make this trial special for me anyway. It's me again says, the box fort has no grounds for foundation. Box fort must go. Y'all are not right. I swear you're not. We know you're a Brooksaholics, Lori. Oh, Nancy, I hope you feel better, honey. For those of you just coming in, we're about to watch a couple of clips here of the morning session after I go through the chat really quick and say hello. Cecilia, good evening. How are you? Was it near the salmon or the tuna? Y'all. Hey, dog mom. Welcome in. You say you're new, but you're not new. I've seen you. I've seen you lurking, girl. Oh, Brenda's coming in from Germany. Tony says, nip it in the bed, get from the get go. What does that mean, Tony? I'm on the naughty list, Mark. You just want to put me there because you're on the naughty list already. Are you watching it from the casinos, Mark? I bet you are. Took a little break from that slot machine, that blackjack table, that poker table. Lori says she's just a little emotional right now. Patty thinks the sandwich is a PB&J. I'm leaning. You know what? I would think PB&J would be the easiest, right? You find a stranger. They say they're homeless. The first thing I would do is fix them a PB&J. Yeah, but you know what? He's a guy. He might have ham in his refrigerator to fix ham sandwiches. You know how that works. Carrie wants to know, is she muted? Am I muted? What's up, hippie chick? We are very special. And the Oscar for the best crier goes to Darrell Streep. That's funny, Steve. That's a good one. Hey, Bama Green Eyes. You hiding stuff from a jury? Did you seek to testify? This trial is biased. Did you know there was, did you see the license plates or a parking plate not upholding your oath of office, Your Honor, as treason? Hello, Tequila. That poor finger almost lost it due to a tiny cut. Infections are bad, especially in this day and age of medical care. I got chocolates on my ankles. Mark has been a member for 2 months now. Only 2 months, Mark? Oh, the pain. Oh, you're going to casino tomorrow. You guys, tomorrow is Mark's birthday. Should we sing to him? Noreen wants to know if she's muted. And Show Poodle's dog is pissed because she's still watching this trial. Still mad. Dog's still mad. That dog, it must be a chihuahua. I swear. If it's got an attitude like that. I mean, really? Fatigue, loss of taste. It's not COVID day, no. Harry is also a little emotional. You guys. Ah, I'm not questifying. Is it my turn to cross-examinate? Okay, for those of you, for the people coming in that don't like all this, I'm sorry. We do. But you know what, guys? So this weekend they had the parade. They had the Christmas parade in Waukesha. And I think we need to play a little oaf. No, we need to watch a little bit, but I clipped out just 2 sections that I wanted to watch from 2 different angles. Um, this one is the one from WISN, I think. I need to turn this music off because I don't want. Last time I played music, I got struck. So here come the dancing grannies. Do I have this on fast play? Let me double check. Nope, it's on normal. Did any of you guys watch this yet? Tony, I haven't gone through half these boxes yet. Are these all exhibits? What else do you what else can't you remember that you don't recall? Better hush my mouth about chihuahuas. Girl, that's my breed. I love me a chihuahua. That's what Bruiser is. Chihuahuas are my favorite because they always bite, most of them. Rhonda says, I'm just a little tender. I know, aren't they cute? They're so freaking cute. Okay, so that I think what that was is I had fast when I taped it, I taped it on fast speed. But I wanted to show you guys this because this is coming in from this is actually the city of Waukesha's YouTube page. Excuse me, YouTube page. And I thought that you guys might want to go over there at some point and watch the whole thing. If you're interested in watching the whole parade, it's the city of Waukesha's YouTube page. But we're just going to watch this one section when the grannies go by. Oh, has your chihuahua been taking care of you? I'm telling you, they're so loyal, and it's my favorite breed. I love me some pit bulls too, though. Yeah, I just thought this was sweet. Look, you notice that y'all, the Dancing Grannies group seems to have grown. Is it just me, or do you think they've grown? It seems like there's a lot more of them. I also noticed in this same parade there was another group of elderly ladies dancing, and I wonder if their group has been around as long or longer than the Dancing Grannies. But I think that Leanne, Virginia, and Tamara would be so proud, and Bill. They'd be so proud of them. They look great. I wonder if there were any dancing grannies that couldn't continue on doing this anymore after what they went through with that. I can't imagine. So anyway, if you guys want to watch the whole parade, go over to the City of Waukesha's page, and it's there on their live stream. Okay. So let me take that off. Oh no, we got to go to the trial. We got to watch this page. Ugh. Are y'all ready for this fool? This is day one. So what we're going to be doing is going through just the morning sessions for this next week or however long it takes, right? And they are naming a baseball field after Jackson, and it's going to be. I've got a whole video on that somewhere. Y'all look in the playlist under the Waukesha Christmas Parade. There's a whole playlist. It's the Jackson Sparks Memorial Foundation or Jackson Sparks Field or something like that. Who's the dude in orange? All right. Yep, it's step shuffle day. You're absolutely right, Naomi. Let's get to it. Get your bark bags out.
All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. Record should reflect that the state appears this morning by District Attorney Sue Opper, Deputy District Attorney Leslie Basie, Assistant District Attorney
Thank you so much, Janice. You're so sweet.
Zach Wichow, and the defendant Darrell Brooks appears in person in custody. I'd also like the record to reflect that he is appearing in jail attire today. He's also wearing a mask.
And would like the opportunity to state that I'm here concerning this matter as third-party intervener in this matter, appearing as authorized representative for my accept for value in return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and would like to now reserve my rights if I may.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this morning.
I just wanted it stated for the record. that
Mr.
I'm not
Brooks,
identified by
It
the name
wasn't
that
the
you called me
proper
by, that's
time to
all.
do that. That's now the third interruption. So,
With all due respect, Your Honor, every
Mr.
time
Brooks,
we,
by
every time
saying
we,
all due respect doesn't change the fact that you're interrupting me. Your objection is noted, all right? But you need to stop interrupting me so I can get through what needs to be done.
but it is
I
my
have a
right
number
to-
of documents
is
that I
my
need
right
to discuss
it
this
is my
morning.
right to-
Mr. Brooks, you do not have a right to interrupt the court.
No, it
I
was-
will
that
remind
was
you
not
once
my
again
intention.
of the Supreme Court rule. It's on a yellow laminated, double-sided piece of paper that is before you. I
did not
checked, I
recognize
verified,
that.
it
I
is.
accepted in return for
Mr. Brooks,
value,
that's
Your
yet another interruption. Let me get through this, please.
Honor. I just want, for the
You will
record,
have an opportunity when I
I-
give you an
I want
opportunity. No
to
one else
state it-
is speaking at the moment but me. You need to stop interrupting.
I don't identify by that name.
Mr. Brooks, I am going to keep going. You are warned. You need to follow the
You guys know that the media, when they were watching this first day, they were like, oh, hell yes, this is going to be a gem.
standards of courtesy and decorum for the courts of Wisconsin. Chapter
I
62,
intend
that's
to, Your
another
Honor. I
interruption.
intend to follow decorum.
This court comes with a history of Mr. Brooks interrupting now. This is day 4, and every day Mr. Brooks has interrupted. It has resulted in Mr. Brooks being placed in a neighboring courtroom so that this court can efficiently, effectively, and with dignity preside over this case here today. I am well aware that's another
respectfully, Your Honor.
interruption. I'm
I-
well
I
aware.
object
Stop
respectfully, which I
talking.
have the right to do.
I'm well aware,
And
Mr. Brooks,
I
that
have
you
not
object to the
intended
name that
cause any,
has
disruption.
identified on the information and all documents in
want it
this
noted
case.
for the
Your
record that I
objection
did
is
not
noted. It
identify
does
by
not
that
need to be
name.
repeated. I will make a record right now. The
May I
court
have the
notes
opportunity to
a
preserve my
continuing
rights, Your Honor?
objection by Mr. Brooks of his name and that he objects to being here. I know he's filed a number of documents previously
I never
related
objected
to
to
that.
being
Those
here. I just
documents
state-
are
I tried
of
to
record.
state
There's
that
another
for the record,
document
Your
that's
Honor.
filed. At least 2 more interruptions just now. I believe I'm up to 8. Mr. Brooks, you're advised that continued interruptions will result in you forfeiting your right to be present in this courtroom, where you'll be taken to the courtroom next door to appear by video and audio
I don't
means to
consent being
participate.
removed from the courtroom, Your Honor.
That's another
And you
interruption.
haven't shown me any lawful case law that I can be removed from the
Mr.
court
Brooks?
proceedings in a trial and forced under coercion and duress
Coercion.
to appear in the trial that I am needed, that I've tried to express that I have the right to
Mr.
be
Brooks, there's a
present for.
proper manner in which you raise objections. You have not followed that proper procedure. You are unable or unwilling to abide by simple rules of civility.
You haven't
You
given me the
interrupt,
chance to-
you don't wait for
state my
anyone
name.
to finish. And it will result with you being removed from the courtroom. So you
respectfully
are
object to that,
once
Your Honor.
again reminded of that. I'm going to give a little slack at the moment only because we are not in the presence of the jury. I'd like to go through a couple
You know, she felt like she couldn't even take a breath because if she did, he would start talking again.
of things, the first of which is the jail attire. Mr. Brooks, we, meaning myself and the jail, have made arrangements by allowing folks to bring in street clothing for you. You've appeared previously in a suit and tie, very appropriate for a trial. If you no longer have those clothes available, the jail has a supply of clothes that they can also lend to an inmate. The reason we make those arrangements during trial, sir, is because this court has taken a number of steps to shield from this jury that you are in custody. Your hands are not shackled. Okay, there are skirts
My
around
feet are
each
shackled.
one of the tables. I'm aware of the feet shackles. That's yet another
Shackles.
interruption. I'm aware of the shackles on your feet, And that's why the skirts are on your table and frankly, all of the tables, right? So that it appears to be the same for anyone coming in and viewing. Again, arrangements have been made for you to appear in street clothes or civilian clothes. I would like you to appear in street clothes. And the reason why, sir, is to reduce or even eliminate even the appearance that you are in custody. And it is your choice, though. Are you willing to go back to your cell and put on your suit?
It is my right to do so or to not do so. And at this point, Your Honor, who doesn't know that I'm in custody?
Mr. Brooks, I've had many trials with individuals who were in custody. And when I've talked to the jurors after the conclusion of the case, they had no idea. The whole point of allowing for street clothing is not only to shield jurors from the fact that you are in custody, but also you being in a suit and a tie or other street clothing, I think also lends to the dignity of the proceedings. This is a trial. Again, it is your choice. Are you willing to go back to your cell and be dressed in the street clothes that you previously appeared in?
With all due respect, I do not agree with that assessment whatsoever. There's no possible way that anybody will not know that I am in custody. I think that's a well-known fact because it's reported on every day in the media. It's shown every day on the news where I am, what jail I'm housed in, and that I'm in custody. It's virtually impossible for anybody to not know that I'm in custody.
Mr. Brooks, did you hear the question that I asked you?
And I respectfully keep the position that I just put on the record.
Mr. Brooks, I will ask you again. Are you willing to go back to your cell or into the jail and put on street clothes?
I do not consent or agree to anything that you just stated, Your Honor.
All right, he did not provide an answer to a very direct question. Let the record be very clear that Mr. Brooks was given multiple opportunities to answer that question. And go back, Mr. Brooks, that's yet another interruption. I will advise you, sir, that at any point in time, if you wish to put street clothes on, I would give you that opportunity to do so. You've already heard it is my preference. You've already heard me advise you regarding the steps that have been taken to shield the fact that you are in custody from the jurors. You refuse to answer my question about whether you would go back to the jail. That's another interruption. So based on his refusal and his choice to come, that's another interruption. Based upon his failure to answer my question directly, I will take that as a non-response, but he came to court here today. That's another interruption. I will take that because he's come to court here today in his jail attire, that is a choice that he has made freely, voluntarily.
You know, those attorneys that he let go, you know, they left marks on the floor running the hell out of there. They were like, bye. They looked at the prosecution and said, good luck with that one.
And intelligently, no one has forced him to come to jail in those clothes. This court is encouraging him not to. He's appeared previously in his street clothes in what I would describe as a very nice suit and tie, but it is his choice to not do that, and we will proceed accordingly.
So while we're on the record, may I challenge the subject matter jurisdiction?
No, you may not, sir. You need to file a motion in order to do that.
So
Mr. Brooks,
I filed haven't even been responded to. I gave
Mr. Brooks, you're interrupting me yet again.
Just weren't speaking,
all right,
so
Mr. Brooks, you are now going to be removed to the other courtroom.
To that.
I have had a dozen or more interruptions. We'll be off the record while we do that. Thank you,
I don't agree to a stop. Well, I'll move for a motion to dismiss for being under duress and being coerced into a contract that I did not consent or agree to. I do not.
Estoppel, coerced.
I have a right to be present for trial.
Is she still listening? She's still there? I'm gonna keep talking till she comes back. When she comes back, I'm gonna keep talking. All right, so let's speed up. He's so stupid. All right, now this part can be a little because she's gonna go over jury instructions and all that kind of crap. So, but if I might speed it up a little bit.
Respect for the simple rules of civility.
Do you guys think that he lost his shirt because when the bailiffs were pulling him out, he was like fighting with them and his shirt tore off? Or do you think he came out of it because he wanted to be like the Hulk?
He has been removed from the courtroom multiple times. This morning alone, he started interrupting this court within a minute of the court calling the case. I should also make a record at the moment he is muted because of the way that he was removed from the courtroom and his conduct since. I have been given just a bit of information about it. I will advise everyone that I have required that the Sheriff's Department file a written report with the court regarding Mr. Brooks's conduct. I'm told that he would not sit down while in this courtroom in order to have the shackles removed so that he could be taken to the other courtroom, that he was resisting, that at one point he took off a shoe and it appeared to the deputies that he was going to throw the shoe. You can see that he is seated with his back to the court or to the camera. He took his shirt off as well. I'm also told that he is threatening to throw and break items. I want to give him headphones since he has claimed in the past to be hard of hearing in one ear, but given his statement that he would throw and break things, unless he can pledge to this court that he will not do that, I'm not going to provide that information. I will advise that the audio in that courtroom should be turned up accordingly so that it is louder than it has been. I've also been advised that the audio and visual equipment is working in that courtroom. The deputies that are in there can see and hear the court through the Polycom system. Today is a little bit different in that there is no Zoom. And so, but this court, with the blessing of technology in this new building, have the ability to call in one room system to the other. That is why we're able to see and, when appropriately, hear him when unmuted. And then there are the 4 camera angles that are presently from this courtroom. I have the camera in the other courtroom on a single camera since he's the only individual in there. This court has, in essence, extended this courtroom to the neighboring courtroom. While there is ample evidence in the record, not only through the proceedings up to this point, but this morning alone, that through his conduct, he has forfeited his right to be present, I'd also make a finding that he is appearing from that courtroom, and that because of the audio and visual equipment and system that we have in place, that it is the functional equivalent of being present in this courtroom. This court has relied repeatedly on Illinois versus Allen. I've read portions of that case into the record. I don't intend to go through that at length here today, other than to indicate that trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula exists for maintaining
Okay, so what I was gonna say is, Diane P, thank you for coming in. Nice to be. Lurkers are always welcome. Nice of you to be here. Just turned her down because
he does that by his choice. I gave him the opportunity to go back to the jail to put on his suit and tie or other street clothes. He refused to answer that question. This court will continue with this trial, as I have previously indicated. There are many resources that have been put into bringing this day to bear, and it is important for all involved that this trial continue. Again, Mr. Brooks is given the opportunity to appear from that other courtroom. At this point, I'm still in the final housekeeping matters, and so he clearly has forfeited his right to be present for that. I will advise Mr. Brooks, as I have advised him repeatedly, if at any point in time he wants to come back and he is willing to promise that he will abide by the rules of courtesy and decorum and be civil and show respect for the court proceedings for all individuals in this courtroom, including Mr. Brooks himself, then he may come back in. It's also my intention to give him that opportunity at each new stage. But again, we are in the
My pinky
preliminary
finger.
stage prior to the jury being brought in.
She was laughing, you guys. She was laughing at how ridiculous he is. Hey, you guys, show some love for Jeanette and Diane P. Welcome, welcome, guys. I never noticed her cracking up.
I would note it's a little after 9:06 a.m. At all times throughout the court's statements thus far, since going back on the record, Mr. Brooks still appears to be communicating, or at least attempting to communicate with someone else. I can see his hands moving. He has turned his back. I can tell that he can hear me because he shakes his head no. At a point in time where it's clear he's disagreeing with something that I've said, I believe he can adequately hear, and that his statement earlier in the proceedings that he's hard of hearing is simply another tactic of his to disrupt, to delay, to create chaos. I will further advise Mr. Brooks that his continued behavior, whether it be appearing in court in jail attire, whether it be causing disruptions in front of the jury, that he does all of those things at his peril. But I will, of course, take appropriate steps to limit what the jury can hear if appropriate.
Oh, you're welcome.
All right. I received a note. We need to reset the Polycom system, so I'm not sure what that means. I'll find out, and if appropriate, make a record as to why and whether that impacted anything that was happening in the other room. But at this point, while I'm not going to get off the bench, we're going to take a short recess for that resetting to take place.
I would request an opportunity for then, Your Honor, when we go back on the record, please.
Absolutely.
Bless her heart. First day, and she's already needing a drink in the morning. She's like, oh, God. Y'all, think about it. Go back to their mindsets. First day, they're like, okay, finally, we're going to get this trial started. Finally, we're going to get it underway and get it out done for the people that deserve justice. And this is how it starts. She probably went home to her husband and said, baby, I'm going to need a spa treatment big time after this one. Big time. He got them shock socks, Mark. I got it on, guys. It's coming back up. I'm just skipping through the breaks without trying to miss anything. He is such a victim, isn't he? It's me again. He's such a victim. Deputy dog. You think he looks like
System has been reset. The information I received was that all of a sudden the audio was only going through 2 speakers and not all of them. A simple reboot of the Polycom system over there took care of that, and I've confirmed that it's working properly. Before I turn to you, Attorney Opper, because I'm not sure if Mr. Brooks heard this or not, at the very end, before I removed him, I wanted to make sure that the record is very clear. I will note a continuing objection.
Give him a wedgie.
To the issues he raises regarding his name and other things. There are filings that substantiate that. It will be my position it's not needed for him to do that every single day because I've noted a continuing objection. With that, you wanted to make an additional record?
Yes, Your Honor, it's probably appropriate at this stage. I did want to address a topic that's maybe not been raised in the courtroom, but has been raised in the public, and it seems to kind of go hand in hand with the events of this morning, and that is the mental competency of Mr. Darrell Brooks to proceed to trial. The court is well aware that the district attorney has an obligation and a duty to raise any concerns as to the competency of any defendant to proceed to trial. Any counsel representing Mr. Brooks would have that same obligation, and the court itself, if it had a concern as to the competency of any defendant to proceed, can request an evaluation that's pursuant to 971.14 of the Wisconsin statutes. At no time has anyone involved in this case had a competency concern. And I say that based on the fact that Mr. Brooks has made multiple court appearances, most of them before Your Honor, but at least initially he appeared before two court commissioners. He's had counsel representing him up until last week on this case. And you've made a record with Attorney Perry previously as to Mr. Brooks' ability to understand what's going on and his ability to participate in his own defense. You made a thorough record last week when you went through his waiver of right to an attorney and his absolute desire that he expressed multiple times to represent himself. I would also add to.
Uh-oh. Hey, are you guys okay with me fast forwarding it? Like, I mean, like, it's on 1.25 speed. No, what happened? Oh, that's them. That's law and crime.
He is coherent. He is intelligent. He knows the issues in the courtroom. He discusses what happened in court that day with these individuals he's speaking to. I am thoroughly convinced, Your Honor, that Mr. Brooks is 100% competent to proceed to trial, that his mental capacity is not reduced in any fashion. Anybody that thinks otherwise has no involvement with this case. I would reference the court to today's filing, which Mr. Brooks provided. It is extremely well written. His handwriting is immaculate. It's perfect. The punctuation, the grammar is 100% accurate. He drafted this himself in his jail cell last night, I presume. Maybe it was this morning. He has continued with the same objections that he has been making repeatedly in this case. So he clearly understands the issues. He understands the defense that he wants to pursue. He undertook the effort to have this form notarized by a jail employee so that it is a signed and sworn affidavit. Absolutely no concerns on the part of the state of Wisconsin that Mr. Brooks has any deficiency in his competency. We are 100% convinced that these actions of Mr. Brooks are deliberate and intentional, and they have escalated. And the court has seen this since August 25th or so, as the motions were decided by the court, most of them to his detriment. His behavior became more and more difficult in the courtroom. It started out less aggressive with him sleeping and asking to be able to leave the courtroom. Then we had a toothache. Then we had a situation where he didn't want to come to court, was refusing to come to court. The record will be clear, Your Honor, that each time, and the Sheriff's Department has done an absolutely fantastic job dealing with Mr. Brooks fairly, professionally, respectfully at all times. We concur 100% with the record you just made as to what happened after the recess at about 8:42 this morning as to Mr. Brooks' conduct. These are deliberate actions on his part as we get closer and closer and closer to actually presenting this case to a jury, that he is attempting to derail these proceedings and avoid the inevitable. I want to make that record. I tell this court as an officer of the court, we have zero concerns as to the mental competency of Darrell Brooks to proceed. And we have had many, many dealings with him on the record and off the record that I base that on. I also wanted to add one other comment as to the court's record as to the need to proceed with this trial. We concur 100%. We would also note it's not just a matter of resources. It's the need to proceed to justice. It's the need to get victims who have patiently attended every one of these hearings. They have a constitutional right to trial. They have a constitutional right to a speedy disposition of this case. And that doesn't mean hasty. That doesn't mean reckless. It means efficient administration of justice. And this court has provided that to the crime victims. And we think that's another reason that Mr. Brooks' antics, which is all they are, clearly speak for themselves. This is not his inability to understand what's going on by any stretch.
Opera the chopper.
Thank you, Attorney Opera, and I do appreciate you raising that with the court because I share your observations that you've just noted on the record. I would adopt them fully as if they were my own and make them part of the findings that I've already made on the record. Obviously, I personally haven't listened to the jail phone calls that you referenced, but I do take your statements as an officer of the court. I look forward to further reviewing them, if need be, changing any conclusions that I've reached here today, and I would require you to file that exhibit so that that can be part of the record as well. I would also add to what you have just stated. This court has read through not one, not two, not three, but 4 evaluations related to the special plea that was withdrawn. And those are very recent evaluations where the examiners met face to face in the jail or in an appropriate visitation room with Mr. Brooks, either in July or August of this year. And every single one of those individuals did a mental status exam that's noted in their reports. Frankly, the behavior that we're starting to see here is no different than some of the behavior that was noted by those examiners as well. This behavior is frankly more in line with someone who's defiant, deliberate, and in line with the conclusions related to whether he suffers from a mental disease or defect that would qualify for a special plea. I've not gone into much detail and I won't. Those documents are part of the record, but it's very clear to this court that everything that he has done as outlined by the state and as made evident on the record of these proceedings, that it is the sole intent of Mr. Brooks to make a mockery of this process. And I've stated, and I'll state it again, I'm not going to tolerate it, but there is, I believe this trial needs to continue, should continue, not only for Mr. Brooks as the accused, who also has the right to a speedy disposition. He hasn't exercised it. The victims have a right to a speedy disposition. And it's important for the justice system to go forward with this proceeding. We are at the stage where we are at with Mr. Brooks muted in another courtroom because of his defiant actions. No one else. And I appreciate everyone's patience as the court goes through these things. Frankly, gives Mr. Brooks time after time after time to conform his conduct to the clear expectations, but he just simply flat out refuses to do so. So what I'd like to do is finish with the approval of the jury instructions, the preliminary jury instructions. I will make a record that Mr. Brooks did not file anything in writing regarding a proposed jury instruction as he was advised to do yesterday. If he wanted me to consider something, I believe we had a very clear discussion on the record about that. He was given a full copy of the draft preliminary jury instructions. He was part of that conference that we held yesterday. There was even a discussion regarding where he could find jury instructions with the legal materials that he has access to in the jail. Although he didn't take it with to his cell yesterday, he has had the selected statutes that I referenced yesterday that also have the rules of evidence. And so I wanted to make that record. I don't have anything from him this morning regarding any additional jury instructions. Has the state had an opportunity to now review the preliminary jury instructions with all the changes?
Other than the IFC, did he send her anything that she asked for in court? I don't think he ever did. He tried to fill out the subpoenas, but he never filled them out right.
That were made yesterday.
We have.
Any objection to those?
No.
All right. Mr. Brooks, I'm going to unmute and ask you if you have any objection to the jury instructions that were provided to you yesterday. I'm specifically looking for a yes or no answer, and I'll address further if need be based upon that yes or no. The microphone is unmuted.
Hey, Casey. Am I muted?
Actually, we'll need to turn him up. It's not very loud on our end. Mr. Brooks, did you say one more time? Yeah, but you know what? Your volume's a little low, so we're gonna have them adjusted over there and in here. So give us a second.
That's all I can just picture that female attorney that he had at the bar, falling off her bar stool and then hiccuping after she's drank so many shots because she couldn't wait to get out of there.
Mr. Brooks? Try again.
Am I on the record?
You are on the record. Ooh, that's loud now. We'll turn ours down. Mr. Brooks, yes or no question, do you have any objection to the preliminary jury instructions that were provided to you yesterday?
He's like an animal.
Go ahead, answer, please.
It's crazy.
All right, your objection is noted for the record, and I'm just putting the mute back on. He provided that objection without any legal basis. I muted him just so I could ask this question. I'll be right with you, Captain. Mr. Brooks, do you have a legal basis to object to those preliminary jury instructions? I'm unmuting you. Hold on, it's the volume is not being appropriate at the moment. There needs. Try it again, sir. I apologize for the technical issue. All right, the technical, we're gonna have to figure that out. It's not appropriately working. I do
He thinks it's a
appreciate that he was able to
conspiracy
hear me
against
because he
him.
leaned in to answer, so I just want to make that record. I'll take, I'm gonna go take a recess. I'll just mute while we're doing that, just so I can figure out what the audio issue is, and then we'll go from there.
He thinks that they're doing all this stuff with the audio on purpose.
When I needed to take the break for the audio issue, I also was advised by the captain that Mr. Brooks was requesting medical attention and reporting a small cut to a finger as a result of when he was removed from this courtroom and taken to the other courtroom. I was further advised that there are no signs of blood, and that when asked, he refused to show his hands. At this time, I'm not going to pause the proceedings further for him to be seen by jail medical, but at an appropriate break, that will be done.
I'm in pain.
And I also want to make a record that Mr. Brooks has put his shirt back on. He continues to sit with his back to the camera. Mr. Brooks, I want you to be advised that I believe it's important that you face the camera so that you are facing the court. You can see and hear. It's my understanding you were not willing to cooperate with being shackled, and for the moment, you are not. But at this point, given your conduct from before, I'm going to require, after we take the next break, that the Sheriff's Department put you in the chair face forward and with shackles on your ankle as you are in custody, and that is appropriate.
I like that
Now,
she
I
said
want to
that.
turn back.
I like that she said that, guys. I didn't think about that because he's being so disrespectful, and she's like, Because people say she let him get away with too much, but she did. Good for her.
Back to the issue with the jury instructions, Mr. Brooks, you indicated you had an objection. My next question to you is, what is the legal basis for the objection? I'm going to unmute so you can answer. Go ahead, sir. You need to turn around so I can hear you. Part of the issue is he's also not facing the microphone, and so I need to hear him, and he needs to turn around.
Also, keep in mind, guys, he's doing this while he knows the victims' families are in the court. I mean, just utter
Mr. Brooks, I'll ask
disrespect.
you once again, what is the legal basis for your objection to the jury instructions? I'll ask a third and final time, sir, what is the legal basis for your objection to the jury instructions?
I wasn't loud, so I can't even hear what she's saying all the way, man. Yeah, it's too low.
You want your headset?
Mr. Brooks, I can hear the deputies over there. I know they can hear me. That's been confirmed. There is the headset available to use should you wish to use it. If you can't hear, I would ask that you put them on.
Just put it down.
I'm able to hear. He said to the deputy, put them down. I don't want them. All right, I'm going to mute once again so I continue with my record. He did not answer the question, what is the legal basis for the objection? I asked that question 3 times based upon that non-response. His objection is noted for the record, and I will approve the preliminary jury instructions that are on file with the court. Obviously, they'll be uploaded once I read them, but all parties have been given copies of those.
What does froggy mean, Tiffany?
Before I turn to the motion for reconsideration, you raised this earlier, at least the topic of it. Mr. Brooks presented a filing to the court this morning. I asked the bailiffs before the case was called at 8:30 if Mr. Brooks had any paperwork and to ask him if he had any filings. He then provided this piece of paper and it was photocopied. Actually, it was date stamped, then photocopied for the parties. It may have already been scanned in, I'm not sure, but it certainly will be. I've had an opportunity to review this document. Based upon my review, I don't believe any response is even required. It's his affidavit. He's providing certain disclosures, but there's nothing about that that requests any relief from the court. Certainly no legal statutes or constitutional provisions are referenced. To me, it just looks like an objection that he's filing, and that will be, of course, noted for the record. Attorney Opper, anything you would want to add to the record on this, any position you are taking?
No, I also viewed this as, because he labeled it objection by affidavit, I think my interpretation is he was trying to make a record for appeal that he objects to the court's previous ruling. I don't think there's anything the court needs to do with this document at this time.
All right, thank you. Then we'll move on to the motion for reconsideration. And again, I'm keeping Mr. Brooks muted so that I can get through this process orderly, efficiently. When necessary, I will unmute him if the court has questions. All right, Attorney Opera, I have read through the motion. Is there anything you want to add to what you have put in your filing?
Only one other observation, Your Honor, that since I filed at the events of the last couple of days, I think further support my request. Not that the defendant's behavior in the courtroom has anything to do with the broadcasting of victims and witnesses, but I think the stress that is going to be placed upon them potentially by Mr. Brooks' behavior will be additional challenge to them as they testify. And so not having their faces displayed, I think, would help ease some of that tension for those individuals.
Mr. Brooks, my first question to you is, do you have a position on the state's request in their motion for reconsideration? I'm looking for a yes or no answer. If you, I'll unmute and provide that to me. Go
I
ahead.
didn't hear what they said. I just put the headphones on, so I didn't even hear what she said.
Sir, it's a written document that was filed and you were provided a copy of that yesterday. We took a recess yesterday so it could be served upon you. If you haven't read it, that's your choice. What I'm asking you is, do you have any position on their request for this court to reconsider the denial of the state's request to prohibit the photography and video recording of victims and witnesses, and specifically their faces while they testify?
A ruling was already, we already talked about that. You already ruled that the victims and witnesses will be shown. That was already ruled on.
You are correct, but they filed a motion for reconsideration. That's the document that was provided to you yesterday. I'm asking if you have any position on the request that I reconsider my ruling.
Yeah, it was everything's supposed to be public. This is a public trial. I don't understand why there would be even the need to reconsider what you already ruled on at this point, as far as to that particular issue.
I take your.
It's a public trial. It's a public trial. Anybody can essentially watch the trial. And like I said, as far as with the technology that we're in now, if they have to be sworn in by name.
that in itself makes them easy to, if somebody wanted to pull them up or find them or find out who was testifying at any given time testimony is given, it'd be pretty easy for them to be found and to be seen. So, I mean, that's just the age we're in anyway, as far as with social media and Google and all these different things. We got all this technology basically at our fingertips. So I don't understand how it needs to be changed at this point when it was already ruled that this is a public trial. There's going to be a lot of things that are going to be shown.
Lord, he's not 5'8".
Why
Ain't no
not
way.
keep everything public the way that it's intended to be? And because of the fact that you've already ruled on it, made that on a record, let's keep it the way it is.
All right, thank you, Mr. Brooks. I appreciate your legal analysis of that and your factual analysis of the prior ruling that this court gave. I thought you did an excellent job making some very good points, many of which I relied upon previously. There is a
You guys know why she's doing all that, right? She's doing all that so that she can have that on the record, that he understands what's going on.
mechanism in the law for a party to bring a motion for reconsideration.
That's not me, by the way. That's them.
Essentially, it requires that the party bringing the motion provide some new information or rely on an argument that the court aired as a matter of law in its prior ruling. The decision that I made previously and the decision that I make here today is one that is vested with the sound discretion of the court. I would note the state does rely upon a case. The case is not new, so it's clearly something that was in existence at the time of the prior motion. That's Estes versus State of Texas. It's 381 US 532, but I would note it's from 1965. In 1965, I would say even in the 1980s here in Waukesha County, there was really a presumption that cameras not be allowed in courtrooms at all. We have moved vastly away from that over the course of the last couple decades, and certainly since 1965. I am certainly mindful of the potential stress that it may cause for victims and other witnesses to come into court and testify and to have their images broadcast as this trial is broadcast, not just locally, but nationally, and frankly, anywhere in the world, anyone with a computer would want to watch. I would note, though, that prior to the point in time when this case came to trial, this court took significant efforts to keep victims' names private. There's a victim key that is on file. This court signed an order and even required Mr. Brooks to not disclose that information. That was one of the conditions set when bond was initially set. Now, that was by a court commissioner, of course, but that's still a ruling that this court adopts. In addition, I believe I've done up to this point everything that I could to preserve their privacy. I don't frankly want to create an issue that could be an appellate issue. I think this potentially could be that if I limit the capturing of victim and witnesses' images. I'm aware of Marcy's law, certainly aware of the provisions that the state cites. But the fact remains, the time has now come for this trial to be conducted. This is a public trial. The right to a public trial is not only for the defendant, but the state, but the public. All of the names are a matter of public record. This court obviously went through all of the names of the witnesses during the jury selection process. It In the jury instruction, the names of all the victims will be read. The state agreed that it was time to put that information in a public document and on the record because the time for trial has come. The cameras in the courtroom not only facilitate the viewing of a public trial where anyone could walk in to this courtroom, space permitted, to watch, but it facilitates victim rights as well. And that is because there are a large number of victims in this case. This court could not have all the victims and the public and the media who wanted to be here present. Frankly, I think it's because of how this court has allowed the proceedings to be live streamed that we don't have even a full courtroom here today. There is no doubt this case has received great public interest, but this is a case that the state brought charges, and rightly so. I understand it won't be easy, it may be messy, it may even be stressful, but it's important to the integrity of these proceedings, the perception of how things are conducted in this courtroom, that all witnesses, that all victims, with the exception of the one thing I accepted previously, be viewed in its fullness to the public. I maintain the exception for juvenile witnesses. They are in a special category as minors, and they, of course, if and when a juvenile witness testifies, may only be captured from the shoulders down. Their faces are not to be broadcast. Again, I am not unmindful of the impact, but in my humble opinion, the right to a public trial supersedes the other provisions, and especially in a case such as this, it's important. I would add to the record some of the points Mr. Brooks made. Not only are these names all a matter of public record, the technology that we have at our fingertips, there's Google, there's social media. It's very easily to identify these individuals and search for them in other ways. I'd also add that there have been a number of news reports, media accounts, newspaper articles about victims, naming them. I'm aware of one such broadcast this morning on Channel 4. I cannot presume that all victims, all witnesses want this. And I want to keep this trial going, and that's what we will do. So the request is denied. All right, I believe, let me just get back to my first note that I had for this morning, that we've covered all of the outstanding issues.
But I did not hear if you, I was kind of overhearing that you addressed the filing that I filed this morning. I didn't hear exactly what was said. I'm just making sure that you know that I'm not trying to interrupt. I just want clarification on what I may have missed.
Well, I was
I'll
still on a
tell you what
tantrum.
I ruled previously. I've reviewed the filing. It's entitled Objection by Affidavit to the state's response and the court's opinion and order and defendant's disclosure statement by affidavit. It's an affidavit. It does not request any relief from the court. I have interpreted what you have filed as an objection to be noted on the record. It has been accepted. It has been filed, and that your objection is noted. The court need not take any specific action as it relates to it. I further indicated that, again, no relief was requested, but also there's no statutory or constitutional or law that you cite to that I could even interpret as a request for relief. So that's how I'm going to address that filing, sir. It's noted for the record.
Can I say one thing about that?
Quickly, sir. I need to keep going.
I was filing that paperwork. I would say pursuant to the federal rules of criminal procedure under Rule 12.4 about the disclosure statement.
All right, I'll note
so
that for the record, sir, but it was not in your filing.
So
Thank
that's
you.
a judicial determination, Your Honor.
Thank you, Casey.
I believe I had one other
You're
thing.
so kind.
Oh, I did want to put on the record, and that is when we were testing the audio, I did advise the sheriff's department to let Mr. Brooks know, to ask him on my behalf if he wanted to come back into this courtroom. My understanding is he declined.
No, that is not accurate, Your Honor.
Mr. Brooks,
The reason
Mr. Brooks,
I would just want
hold on. I'm going to mute you for a second unless you stop and listen to me.
I just heard what you said, but I just.
I'm not
wanted to
asking
correct
for a
it because
response,
it's not-
sir. Mr. Brooks?
it's not- it's
Okay,
not
you're
accurate, Your Honor.
interrupting. Hold on. You're interrupting me, sir. I wasn't looking for a response. I'm happy to ask you the question myself on the record for you to answer it. I will give to come back into this courtroom. You have demonstrated that you can make cogent, coherent, articulate arguments on the record. You just did that. You've been respectful for the time being. I will ask you, sir, do you want to come back into this courtroom? You've been unmuted to answer that question.
Not until I can receive medical treatment for the bruise that I have on my arm and the cut. You just said a while ago on the record that you cannot see blood. That's because I wiped it on my pants and you can still see the blood in the cut and a big bruise right here on my arm. I was told that the nurse would be coming in to see me. And then I was told, no, she's going to come at the next recess, which we just took. I know it was technical difficulties why you called the recess, but that was more than enough time for me to at least be seen, at least get the cut cleaned out and get it bandaged, at least at minimum that, and for somebody to look at this bruise. That was my position on why I was not yet ready to come back into the court, because I feel like this needs to be addressed.
Good Lord.
All right, Mr. Brooks, I understand your request. I'm denying the request to take an adjournment, or I'm sorry, to take a break at this time.
I'm not asking for a break. I didn't ask for a break. I was just saying that at the time that there was the technical difficulty recess, before you even called that, Your Honor, I was told that a nurse was coming in at that time. But then when you called the recess for the technical difficulty, I was then told that I would have to wait until another recess to be able to be seen by the nurse, which my thing was, I
Mr.
wanted
Brooks,
to
you've
get
made
seen
your
by the
record,
nurse.
okay? I don't need you to go further with that. You've made your record. I'm going to mute you for the time being. I want you to be aware, sir, I was advised regarding the cut. The bruise is new information. I made a determination that you would be seen at the next appropriate break. From my perspective, a small cut and a bruise is not going to hold up the start of bringing the jurors in and advising them of the preliminary jury instructions. If that means the next break we take is for lunch and that's when you are seen, then that's what will happen.
Get the medic in
So,
there.
I don't think I've overlooked anything, Attorney Opper, but anything you had on your list?
Nothing else on my list, but we want to give Mr. Brooks one more opportunity to change out of his orange jail uniform. Excuse me.
That I would give him an opportunity to do.
Oh, she's wants to piss
Mr.
him
Brooks,
off
would you
with
like
that.
to go back and change into your suit?
My position has not changed whatsoever, and it will not change, as it is my right to come into court how I would like to.
Like an
Just
idiot.
like I should be awarded the right to be present for every proceedings in this trial.
All right, I'm muting him again. I note your objection. I will take that as a clear indication you do not want to go back to the jail to change into street or civilian clothing, that you are exercising your right to dress in the jail attire. All right, then with that, I am going to just take a short recess just to have the jurors brought in.
Thank you, Mark. You're so kind.
Objection sign.
We'll make sure he has it.
Thank you.
Objection sign. His laminated objection sign. He's so mad.
Let me actually go back on the record for a second. Mr. Brooks, when the jury comes in, I am going to read through the preliminary jury instructions. Since those have been approved by the court, if you happen to raise your sign, I'll note it for the record, but I'm not going to ask you for any type of argument on that because we've already had that opportunity to do so. It will take me some time to read through the instructions. I don't know if that will take us to the lunch hour or not. The state should be potentially prepared to go through its opening. Mr. Brooks, if we do get to that point where the state is giving its opening and you have an objection, you need to write down the objection in addition to raising your hand, and I will rule on the objections after the closing statement. So you must write down the basis for the objection and what you're objecting to. In addition to
No, I
holding
ain't
up your sign, that's the
I ain't gonna do all
procedure
that.
that we will follow.
I ain't gonna do all that. You see, you trying to be
Right
slick.
now we're on a short break until the jury comes in.
You trying to be slick. I'm objecting now. Hey, am I muted? Damn, man. Hey. Man, oh man, what y'all trying to pull, man? Ain't gonna work. Ain't gonna work. You can't coerce me like that. Where's the lawful law? You ain't even got subject matter jurisdiction. Your Honor, with all due respect, I want to see your law degree. You ain't even got a degree. You ain't even got a license, Lisa. Oh my gosh. You guys. We could literally just leave him on mute and watch him and laugh, right? Thank you, Mark and Casey, for the memberships. Hey, let me know who got them because I can't see on this side. Wonder of what's ahead. Too bad. I know, right, Diane? Too bad we couldn't have warned the judge what's coming up. Her reward was when she got to sentence him. Everybody wanted to be in her shoes on that day. Okay, I think I'm going to have to fast forward this, guys.
Do not begin your deliberations and discussion of the case until all the evidence is presented and I...
Because we really don't want to hear the jury instructions, do we? How many times do we have to listen to jury instructions as crime advocates, true crime advocates that we are? Hey, Joe Record.
We will stop or recess from time to time during the trial. You may be excused from the courtroom when it is necessary for me to review
Let me see if I can do one. Hang on. I'm going to give some memberships.
Do not speak with them. For their part, the parties, lawyers, and witnesses will not contact or speak with the jurors.
No, I'm going to wait. I'm going to wait because I've only got 5 left.
Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional
You know, if she
information.
had shock devices on its ankles, all they would do is pay for all the medical bills. Is kind of offer up who gets to hold the button. That's great, Jeanette.
Explain or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer.
She probably took up yoga, Janice. Oh, Lord, have mercy. You needed some kind of release if you had to deal with him for almost 3 weeks straight.
Social media posts or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by other means. If anyone does so despite you telling them not to, you should report that to me.
Is it my turn to hold the chocolate button?
To discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After the trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report it to me. If jurors do not comply with these rules, it could result in a new trial involving additional...
Meanwhile, you guys, they are over 2 hours into the day, and she has just now started reading the jury instructions. Zach is sitting over here ready to give his opening statements all day. All day. Show poodles. That's hilarious. That's when day drinking became all the rage.
You should pay careful attention to all the testimony because you must rely primarily on your memory.
Was she in the parade?
Introduced at the trial. During the course of the trial, the parties may refer to or use police reports with witnesses. Normally, these police reports will not be provided to you. If you are not provided with a police...
Zephyr says Judge Darrell was in the parade this year. We just, before you got here, Zephyr, we were on, the first thing I showed was little bits and pieces from the parade. If you guys go to the City of Waukesha's YouTube page, you can watch the whole thing. I did not even notice that she was in one of the floats. That's pretty cool. That's really cool. Well, while she's reading this, we're going to stay on. I'm going to keep it on mute so we can talk here. John Bubba says, I better Judge Darrell had her wine order on speed dial at day's end. She just pulled up and said, I'm here. And they brought it out to the car. It was COVID. So, you know. What do they call it when you pull up and they deliver it to your car? All that blood, it makes me weak as I'm going to pass out. That little pinky finger cut. I'm sorry, but really happy I'm not the only one watching this. Dina, girl, you got to join our club. We have a Hiki and a Kiki club over here. And we're ridiculous. We can't help it. We are ridiculous. We can't get out of it. We're booksaholics. Anonymous in a bad way, in a good way. We don't like him. Melanie says, so first person they should call is Dawn and say, so Dawn, you called 911 and said you saw your son, Darrell Brooks Jr. driving your car on the news and said he stole a car. You can't drive that you purchased. He stole the car that you can't drive because you don't have a license, but that you purchased. Am I saying it right, Melanie? I think I am. Hey, Teresa. Welcome in. You just missed his chipmunk. What they used to call them, the chipmunk dancers. Chippendales. But Brooks is a chipmunk dancer. What's this? I'm at intervention levels watching this trial. Well, we are trying to wean ourselves off, Dina. I mean, we're gonna go down to like 2 to 3 a week instead of 6. So, it takes time. Anyone who's you stay long enough, you'll get a chip on your shoulder, but not the kind of chip that they give out in AA. You notice anytime that Opper said something, he was like, she could have said his shirt was orange, and he would have been like, no, I ain't going, ain't gonna tell me what to do. Ain't gonna tell me what to do. It's tangerine. You know what I mean? Like, he hates Opper. She got under his skin so bad, it's funny. She should send him a Christmas card every year in jail. I just think she should. It's nice to think that during the holidays, he's sitting in a cold cell. Yeah, anything he can do to delay, he's going to do it. He knows now he's been shut dead, so he's going to. But I find it interesting, though, that first day out, out of the gate, he's trying to set the precedence. He's going to come in and say, this is what I'm going to do. And every day, it's like every day he came in. That's why I wanted to do the morning sessions and just stick to doing morning sessions, because it's as if every day he had a new thing that he was going to throw out at the judge at the court. Because I think it was day 3 or 4 where he came in and he called the state of Wisconsin to testify. It was just then you've got the COVID day. Every day it was something. Look at him. I know, right? It's almost like they had to cater to him. That part of their job probably really ticks them off, that they have to kind of take care of him like that. Sue Opper does rock. OG Opper. I hope by now Erica's knows that being away from him, she kind of sees it now. Because you got to get away from him to see things. I think she's seeing the light. Lori says, Opera rocked this trial. Yes, she did. Hey, Glenn, where have you been? I haven't seen you in a while. Glenn said, speak that, Opper. Every single time she could, the Oracle, she'd call him out. And I think she had a thing. She can say she didn't, but we don't blame her for it, because I would have done it too if I was her. Dina, if you can, I apologize if y'all heard me drink. I'm drinking coffee. Dina, if you heard us repeating all the things that they say, you know. Opper is retired now, Lori. John Bubba says, Mike must be grilled because she's dropping it like they're hot. Oh, that's funny. Okay, let me check back in on the video. Oh, yeah, this goes on for a while, you guys. We got a while. Take a breath. I don't know how she reads it. I don't know how she reads all that without having to take a break. rush to judgment. Release the phone calls. No doubt, Wonder Joy. I want to hear them. Our justice, Zephyr's right. Our justice system needs to get back to doing what is best for the victims. This was sick. No creep should be allowed to torment their victims in court like Brooks did. Preach. I agree 100%, girl. Yep, Jason, he is doing the same thing now in prison. He's a hypochondriac. He's just looking for reasons. Well, they say now he's doing it just to keep going to medical because he's so scared somebody's going to come get him. John Bubba says he wears the Juvies girl size orange. He was abusive to his mama, too. Hey, I'm not giving her any credit. I'm just saying she got what she dealt out. You want prison video? I don't know about prison video. Ooh. All right, come on. Give me some one-liners, you guys. Here, let me check back in with the audio.
If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 3, you should find the defendant guilty of first-degree intentional homicide as charged in count 3. If you are not so satisfied, you must find the defendant not guilty as to count 3. If you find the defendant guilty of count 3, you must answer the following question, yes or no.
For
Did
Tan,
the defendant commit the crime of first-degree intentional homicide while
his
using a
behavior, I wish she'd have stayed this
If you
way
are
the whole
satisfied beyond a
trial.
reasonable doubt that both
Yeah.
elements of first-degree intentional homicide have been proved as to count 4, you should find the defendant guilty of first-degree intentional homicide as charged in count 4.
Hey,
If you
Gen
are
X,
not
I didn't see
satisfied,
you.
must find the defendant not guilty as to count 4. If you find the defendant guilty of count 4, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt.
Barbara says the Wonder Woman judge deserves whatever she wants for Christmas for the rest of her life. She does look like Linda Carter.
If you are not so satisfied,
I keep saying she's going to get paid to do a shampoo commercial.
if you find the defendant guilty of count 5, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 6, you should find the defendant guilty of first-degree intentional homicide as charged in count 6. If you are not so satisfied, you must find the defendant not guilty as to count 6. If you find the defendant guilty of count 6, you must answer the following question, yes or
All
no.
right.
Did the
I'm going to
defendant
speed
commit
up
the
a little bit,
crime of
y'all.
first-degree
Because nothing's really going on. He's holding up his sign. She's reading jury instructions.
Contrary to sections 941.30 sub 1.
Now he's even got it in his pants. What an idiot.
Using a dangerous weapon.
He's
If you are
such an
satisfied beyond a
idiot.
reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 26, you should find the defendant guilty of count 26. If you are not so satisfied, you must
What
find the
happened
defendant not
here?
guilty as to count 26. Follow in terms of me addressing any objections. So if he wants to write down what his objection is, and we'll file that. We'll also indicate
I think they went to
hopefully
lunch.
I'll take that up after the break, but at this point I will be breaking for the noon hour for the lunch hour. It's 12 noon.
Okay, now they're going to lunch. We'll catch them when they come back. So they wasted a whole morning on his antics. That all they've gotten done. They should have been into the opening statements by now, or past the opening
Right.
statements.
Thank you, everyone. I wanted to put one, we're back on the record. I wanted to put one other thing on
hang
the
on,
record.
sorry.
Based upon the attendance at the trial thus far, and given the number of victims, I am going to now reserve all of the benches behind the prosecution table for victims. They will no longer be available for media or the public. From my perspective, there's ample room on the other side of the courtroom. I'll ask the district court administrator to assist me in modifying the trial administration order, but that was my observation throughout. Ample seating, that does take away a bench from the media, but from my perspective, they've been watching, I think, from the media room based upon the pool feed, and they no longer need the 2 benches.
Thank you, Your Honor. We greatly appreciate that.
You're welcome. All right, then I'll have the jurors brought out momentarily. I just want to get confirmation from the bailiffs who are with Mr. Brooks that they offered, based on my direction,
Mr. Brooks to come back over here. I don't know what his response was. Mr. Brooks, I'll ask you and advise you, you are welcome to come back to this courtroom. You've been conducting yourself in that courtroom, at least prior to the break, in a way that seemed to me that you were writing notes, perhaps even following along with the written jury instructions. I know you filed 2 objections. Those were addressed earlier. Mr. Brooks, if you're willing to abide by the rules of courtesy and decorum, you are welcome to come back. Would you like to come back to the main courtroom?
Can y'all hear me?
Am I
You're on the
muted?
record. Would you like to come back to the main courtroom? And if I could just get confirmation from the bailiffs. I know the audio was tested. I was under the impression it was working, both audio and visual. Do you know if anything what I said was picked up? Okay, thank you.
I can't hear in my one bad ear.
Looks like Mr. Brooks has put on the headphones and they're testing them to see if they are working.
He don't need no damn
I
headphones.
don't believe he had those on prior to the break.
And we all know it.
My notes show he had removed them at about 10:54 a.m. and when we broke for lunch, it was about 11:54. So it was about the last hour of the morning session. He was not wearing the headphones, Your Honor.
Thank you.
Get him, Sue. She,
I believe those headsets do need to be charged.
It's like
on
a hall
occasion, so
monitor.
there are other headsets that can be provided if that one is not working.
yeah, the headset broken's not going to work, Brooks.
Looks like a new battery
Hey,
pack,
John Cooper.
charger pack for that was provided. It's not the headset, but the attachment that gets charged. So hopefully that works. All right, Mr. Brooks, I am offering you an opportunity to come back to the main courtroom. Would you like to do that? I'm not sure why we're not hearing him very loud at the moment, but can you
He said
repeat
yeah.
that again?
I say yes.
You'd like to come back? All right, we'll have you brought back then. Thank you.
Oh, you want to come back in, huh?
We'll be in recess until that is accomplished.
He didn't want to, but he didn't want to admit it, y'all. He didn't want to admit that he wanted to come back in. Jason says animals have bigger brains than Darrell. Bob Kitten says, don't insult animals. All right. J-Car says, darn, I missed the start. J-Car, you've seen this like 10 times. Come on, y'all. Now, if they go into opening statements, I'm gonna close it out just so you guys know, because then we're no longer in the morning session, and this is just the morning session.
Continues
We'll go to day 2.
Masked. Welcome back, Mr. Brooks.
They never asked me during the break because I had so much other stuff going on. I'm not sure. I'm not saying it was intentional on their part, but I was never asked. I just want to make that clear for the record.
Thank you. I appreciate that clarification. Nonetheless, I provided you with that opportunity, and here you are. Please be mindful, sir, that the right to be here can, of course, be lost if you engage in disruptful, discourteous behavior, if you interrupt the decorum and do not show respect for the judicial proceedings. You would, of course, be subject to removal and forfeiting your right to be present in this courtroom. All right, I'd like to bring the jury out, Mr. Brooks. I am still going through the preliminary jury instructions. I know you filed some objections. Those have been noted for the record, as I advised earlier this morning. Because I've approved of them, there should be no objections. You had ample opportunity to do that. So I'm instructing you at this point not to object, because I will consider whether that's being done for disruption. If you have an objection, write it down on a piece of paper, pass it to the bailiff, and I'll take it up outside the presence of the jury.
Just so I'm clear, are we talking about objections to strictly jury instructions, or the filings that I filed on the 3rd?
I'm not addressing those at this point,
I
sir.
was just asking for clarification. I didn't know which one you were speaking on as far as the objections.
I'm talking about objections during this court hearing to the court going through the preliminary jury instructions.
Okay, I was just asking for clarification.
Right. I'm not addressing any of those filings. I previously addressed those. It may not be to your satisfaction, but,
Remember what you said, to be honest about those.
and I'm not going to repeat myself. So
I love that. And I'm not going to repeat myself. Welcome, Bob. Welcome to the meeting.
the record speaks for itself. Your objections in those filings, to the extent, whatever they are noted. They're part of the record, and they will be available for you at a later point in time, should you be convicted and on appeal, to make whatever arguments that you need to or want to regarding those. But from my perspective, that is something I'm not going to take up any further. And any attempt by you to do that, I will have to consider whether that's being done to disrupt the proceedings and not for legitimate reasons.
My only reason for bringing it up was to make sure that they are offered into evidence.
Sir, we're not at the evidentiary phase. They're part of the record. They've been received. So at this point, there's no evidence to be taken. We're not at that stage of the proceedings.
Y'all think
So
by now
you
he's
will have
figured
an
out how to
opportunity
do
after
that?
the state presents their case in chief, and they rest, to then present your case and to present evidence that's relevant to the issues before the court and the jury. So I'm not going to go through any further on what that means. That would be for me to provide you with an explanation of the law or procedure, but I expect you to not bring that up at this point in time or going forward.
I don't understand, though, Your Honor.
Mr. Brooks, I've already addressed them. I'm going to bring the jury out. Please do not disrupt as the jury comes in and as I complete reading the preliminary instructions. I am, just for reference for everyone, I've read through 44 pages of 69. And so I still have a ways to go. My intention would be to finish with the preliminary jury instructions, take a short break for all, including the jurors, and then come back with opening statements. And you have a choice, sir, at that point, whether you want to give one, but the state goes first because they obviously have the burden of proof. And then you would have an opportunity to give an opening statement as well. But that's my plan, at least for the afternoon.
I would like to go back over there, Your Honor.
You would like to, you're asking that to voluntarily be taken to that courtroom.
I'm trying to seek to understand how the testimony evidence that was given could be
Mr.
considered
Brooks, I've already
evidence.
dealt with that. I'm not going to deal with it. If you want to go to that courtroom, are you waiving your right to be present right now?
Can I at least raise the issue of subject matter jurisdiction?
No, there's no lawful motion before the court. You may not.
Are you making a judicial determination that I cannot?
Mr. Brooks, I'm going to bring the jury out. I'd like you to stay. That's my preference that you stay. You've certainly demonstrated throughout these proceedings that you have the capacity to follow the rules, that you have the intellect to make cogent, coherent, articulate, responsive arguments when you so choose. But when you start doing what you're starting to do right now, going back to filings I've already addressed and start talking about subject matter jurisdiction, that is a tactic by you that I believe is to disrupt and to delay the proceedings.
That is not accurate, Your Honor.
Your
Respectfully-
objection to my characterization of that is noted.
I would like to make a motion for finding the fact in.
Your request is denied.
On what basis?
Your request is denied, sir.
That you're an idiot.
Your Honor, I'm merely seeking to understand on what.
Mr. Brooks, I refer you once again to document 244 that you signed, that you acknowledged, dealing with the right to waiver of right to attorney. We went through all of the advantages, the disadvantages. You were advised of things, including the charges that you face, the penalties that go along with them. We discussed the difficulty of representing yourself. You made a deliberate choice to waive your right to an attorney, which this court honored and granted.
That is
And
inaccurate because I
you,
I
Mr.
altered
Brooks,
the
don't
contract.
interrupt me. Okay, now that's at least the second time. So don't interrupt me. I'm going to continue with these proceedings. Even though you're mild-mannered, even though you're speaking in a soft tone of voice, the conduct still has the same effect. And that's to disrupt, to delay, and to show disrespect for the court proceedings.
It is not. It's not my
Mr.
intent.
Brooks,
It's not my
please,
intent.
I'm not
seeking-
going to force you to sit down. You're welcome to sit down, but I am instructing the jury to come out. You, at your peril, run the risk of me admonishing you in front of them at this point. I don't want to do that, sir.
I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that you want.
I'm
all
not
right?
asking for legal advice.
I
simply-
cannot explain court procedures or the law to you.
I'm
So
simply seeking
with
to
that,
understand.
Mr. Brooks, that's another interruption. You keep going. Stop.
I'm seeking merely to understand, Your Honor. I don't understand the nature and cause of the charges.
Mr. Brooks, I've already dealt with these.
I'm trying to bring up the subject matter
Mr. Brooks,
jurisdiction.
if you keep interrupting me, then you will forfeit your right to be present because you're showing through your conduct that you will not follow the most simplest rule of civility in a courtroom, and that's by not interrupting. You continue to, it's just a tactic by you.
So what are
The
you
fact
gonna
that
say?
you are doing that demonstrates to me that you came back over here, right, with absolutely no intention of following the rules.
If that's what you want to say, that's your assessment. It's not accurate.
Well, my assessment will stand on the record, sir. It's based on my observations.
And
So
I
at this
respect-
point,
I
Mr. Brooks,
respectfully object
stop
to that.
interrupting me, please.
I merely
Stop
just seek to
interrupting me,
understand.
sir.
I'm not. I was
If
in the
you
middle
have
of
an
saying
objection, write it down.
something. I thought that applied to me being.
It's
From
applying right
another-
now since you keep
I-
interrupting me while
So
I'm talking.
what is the purpose of me being present if I'm not able to ask simple questions that I do not understand? I'm
Mr.
just
Brooks,
seeking.
I've been
I'm not
more
asking for
than
legal
patient
advice.
with you. And the trying to raise every time we're in here are not issues I'm going to raise at this juncture or address at this.
I was going to wait till a thing, but thank you so much, Mo. I appreciate you, honey. This man is so extra. Hashtag jail Mama Brooks. Also, thank you, Miss Lori, for your Snapchat. Oh, not Snapchat. Super chat. She said she's sending love. Y'all are so kind.
This juncture in the proceedings.
Is
All
there a
right,
reason
I'm
why?
not giving you advice. I'm not explaining the law. I don't need to do any of that, sir. All right, you filed what you needed to file. I've addressed every single filing on the record. It may not be to your satisfaction,
That's inaccurate.
but I have addressed them.
That's
All right,
inaccurate, Your Honor.
some of your
With all
filings,
respect.
sir, you're interrupting me yet again because you're not letting me finish with my explanation. Some of your filings do not require a specific line by line response by the court. I've addressed them in the way that I believe the law requires me to do. Again, that may not be to your satisfaction, and
That is simply the way that it's going to be.
It doesn't
But
have
we are
anything-
continuing on with the reading of jury instructions. It's important. They're going to come in, and it will be up to you whether you can demonstrate respect and courtesy, not only for these proceedings, but for the jurors that have been selected to hear this case.
Your
Madam
Honor,
Clerk, have the jurors brought
Your
in,
Honor,
please.
what you're doing is judicial misconduct. You're making the judicial determination that I'm not allowed to ask questions, that I'm not allowed to question Your Honor, which is my right. I've
But you're a
merely
sovereign
brought
citizen.
up subject matter jurisdiction because it has merit. I've merely tried to seek to understand the proceedings that I do not understand. You're rushing me to judgment by constantly removing me from the court when I should be present for all proceedings and I should be able to understand, which I do not. Once again, I do not understand the charges, the nature of the charges against me. I do not understand why Your Honor will not answer mere questions that would give me clarification on understanding. I'm not attempting purposely to be disruptive, disrespectful in any manner. But if I don't understand something, it benefits me to ask so that I can have clarity. The waiver that you speak of with the attorney, I gave the right the waiver back in the way that I felt that it should be altered. And you said so yourself on the record that the word understanding was taken off of that paperwork that I sent back to you. That should have let you know right there further that I did not understand the proceedings, and that is some of the issues that I'm bringing up now. It's merely just clarification, Your Honor. I don't understand what is going on. It's not to be disrespectful. It is not
Mr.
to
Brooks,
prolong the
Do
proceedings.
you
It is not to.
understand when I tell you not to interrupt me?
No,
Do you
no, I do not.
understand when I tell you you need to follow the rules of decorum? I believe you do. Please sit down. The jury's coming in.
I still would like to ask
Mr.
questions,
Brooks?
Your Honor.
Stop talking. We are proceeding with the continued advisement to the jury of these preliminary jury instructions. Do not interrupt me. The record should reflect that the jurors in the courtroom.
Your Honor, with all due respect,
Mr. Brooks, stop talking. It's not appropriate at this point in time. You'll have opportunity
I disagree.
later to raise other issues, but the issues that you seek to engage with this court are issues I've already addressed.
You have not. You have not shown proof.
Mr.
that
Brooks,
you have
the
not
jury
shown.
is in the
I
courtroom.
understand that,
You
Your Honor.
continue to talk despite being told to sit down and to pay respect to this court, to these jurors, to the process.
It is my right to stand or to sit, Your Honor. It's my right.
Mr.
I'm
Brooks,
merely
you can
exercising my right.
stand, you need to be quiet. Thank
Your
you.
Honor, Your
Mr.
Honor.
Brooks, please stop. I'm going to continue with the instructions. If you interrupt me, you will run the risk of being taken to the courtroom next door.
I'm seeking to understand, Your Honor.
Mr. Brooks, final warning.
I'm seeking to understand, Your Honor. It must be some clarification.
Mr. Brooks,
You should have kept your attorney.
I want you here.
I want to be here.
Stop interrupting me.
Yeah, we're sure
were
you want to be
quiet.
there.
I didn't-
Mr. Brooks, stop talking so I can read through the instructions.
Your Honor, can I?
Ladies and gentlemen
You
of the
can-
jury,
you can
I'm
move
going
me
to
to the other
continue
thing.
with the jury instructions. I'm on count 38. If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 38, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 38. If you are not so satisfied, you must find the defendant not guilty as to count 38. If you find the defendant guilty of count 38, you must answer the following question, yes or no.
Some of y'all
Did the
crazy.
defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 39, you should find the defendant guilty of first-degree reckless endangering safety as charged in count 39. If you are not so satisfied, you must find the defendant not guilty as to count 39. If you find the defendant guilty of count 39, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 40, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 40. If you are not so satisfied, you must find the defendant not guilty as to count 40. If you find the defendant guilty of count 40, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 41, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 41. If you are not so satisfied, you must find the defendant not guilty as to count 41. If you find the defendant guilty of count 41, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 42, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 42. If you are not so satisfied, you must find the defendant not guilty as to count 42. If you find the defendant guilty of count 42, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 43, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 43. If you are not so satisfied, you must find the defendant not guilty as to count 43. If you find the defendant guilty of count 43, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 44, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 44. If you are not so satisfied, you must find the defendant not guilty as to count 44. If you find the defendant guilty of count 44, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 45, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 45. If you are not so satisfied, you must find the defendant not guilty as to count 45. If you find the defendant guilty of count 45, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 46, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 46. If you are not so satisfied, you must find the defendant not guilty as to count 46. If you find the defendant guilty of count 46, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 47, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 47. If you are not so satisfied, you must find the defendant not guilty as to count 47. If you find the defendant guilty of count 47, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 48, you should find the defendant guilty of first-degree recklessly endangering safety 48. If you are not so satisfied, you must find the defendant not guilty as to count 48. If you find the defendant guilty of count 48, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 49, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 49. If you are not so satisfied, you must find the defendant not.
Is he refusing to sit down because she told him to?
Degree recklessly endangering safety have been proved as
going
to
on
count
forever.
65. You should find 346.74 sub 5 sub D and 939.50 sub 3 sub 5. You should find the defendant guilty of bail jumping as charged in count 75. If you are not so satisfied, you must find the defendant not guilty as to count 75. The 76th count of the information charges that Darrell E. Brooks on or about Sunday, November 21 of 2021 at Frame Park in the city of Waukesha, Waukesha County, Wisconsin, did cause bodily harm to Erica Patterson by an act done with intent to cause bodily harm to that person without that person's consent, contrary to sections 940.19 sub 1, 939.51 sub 3 sub A, 968.075 sub 1 sub A, all of the Wisconsin statutes. Battery, as defined in section 940.19 sub 1 of the Criminal Code of Wisconsin, is committed by one who causes bodily harm to another by an act done with intent to cause bodily harm to that person or another without the consent of the person so harmed. Before you may find the defendant guilty of battery, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 4 elements were present. 1, the defendant caused bodily harm to Erica Patterson. Cause means that the defendant's act was a substantial factor in producing the bodily harm. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. 2, the defendant intended to cause bodily harm to Erica Patterson. Intent to cause bodily harm means that the defendant had the mental purpose to cause bodily harm to another human being or was aware that his conduct was practically certain to cause bodily harm to another human being. 3, the defendant caused bodily harm without the consent of Erica Patterson. 4, the defendant knew that Erica Patterson did not consent. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt that all 4 elements of battery have been proved as to count 76, you should find the defendant guilty of battery as charged in count 76. If you are not so satisfied, you must find the defendant not guilty. An information is nothing more than a written formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. The parties will make opening statements. The purpose of an opening statement is to give the parties an opportunity to tell you what they expect the evidence will show you so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. Before we have the parties, or before I give them the opportunity to make opening statements, I am going to excuse the jurors to address a few legal matters, give you an opportunity as well for a short comfort break. We'll let you know when we bring you back in.
Those jurors really got to bypass a lot of junk. But I don't think they were, I think they were like, ugh, another time, you know, they knew something was going on though. They knew it was all him. Because they saw how he acted the first day. Yeah, he's got to have the last word, Bama. Mind-boggling. I got some stuff I've got some stuff starred that you guys said I want to talk about afterwards. The law library. Tara. You keep bringing up Illinois versus Allen, but nowhere does it say a fourth option, mistrial. Let's all take a field trip to visit him. You want to, Mark? You think he'd see us all? If we sent him a letter saying that we were the Brooksaholics Club, can you imagine? I wouldn't go see him, but I want to make a phone call. I want to talk to him on the phone, get an interview.
Pieces of paper that Mr. Brooks wrote on. I'm going to have them copied so the state can be aware of that and respond if necessary. So we'll just take a moment while those papers are copied.
The shackle two-step. If only the chocolates were real, Wendy. Poor Zach has been waiting to give his statement all day. His openings. Mark's in love with Judge Darrell.
How many copies are you making?
Doro, whatever you want to call her.
Yeah, okay. We'll make sure you have copies of the filings as well, so you know what will be discussed or at least addressed in some fashion. But I need to
I
provide
can't catch up
copies
on
to the
those
state.
chats. Hey, Cass. There's too many to catch up on.
Go ahead, sir.
I noticed that one of the jurors, the lady in the black that's closest to the screen in that corner chair over there, I recognize her from my initial appearance. She flipped me off coming in to my initial appearance and coming out. I know it's her for a fact. I seen her about like how I'm looking at you right now. So I know for a fact that's her. I don't want that to end up being an issue. Is this some type of way that could be addressed by Your Honor?
He said, well, that last thing didn't work, so now I got to come up with something new. So let's, I'm going to come up with the jury thing.
Mr. Brooks, you had an opportunity to exercise preemptory strikes and even to question jurors about that. You chose not to. So at this point, any issue you have with that juror is waived.
Okay, you do remember that I was not present in the courtroom. I couldn't see. All I can see from that courtroom in there is just you, Your Honor, and I can't even see the bailiffs. So it was no way for me to even see who the jury was. Obviously, I wouldn't know them by name. If I would have been able to see the jurors, I would have immediately addressed that.
I will make this one indulgence. I'll have the civilian bailiff ask that juror if she was in attendance at your initial appearance out of an abundance of caution. These are jurors, though, who with the jury questionnaires were also asked what knowledge they had about proceedings they watched or even attended. And no one, to my knowledge, has disclosed anything like that, but out of an abundance of caution, we will ask that juror if she was in attendance at your initial appearance. So for now, that's how I'll address it. I'll advise you of what her answer is. And to make clear, you're saying the chair closest to the television. Thank you.
I said that at the beginning, Your Honor.
Whatever.
Front row. All right. State have copies of the filings.
Yes.
You guys, I give up on putting all your chats up. There's too many of them.
I will take these in order. The first is a note from Mr. Brooks that was handed to Deputy Wittig at about 12:05. It says, I would like my filings addressed, parenthesis, notice of special appearance, statement of particulars, both are by affidavit filed 10/3/22, which today is deadline to respond. Thank you, Mr. Brooks. I'm respectfully declining to respond to those filings. That's my decision, sir. Next.
Are you making a judicial determination that those have no merit?
Mr. Brooks, I have indicated to you on the record what I will or will not do.
I would like to motion for finding a fact.
Your request is denied. The next,
May Your Honor explain why it
Mr.
is
Brooks,
denied.
I'm gonna go through these one by one. If I feel the need to make more of a record, I will do so. The record will be available later on. If you think I've made an error, you can then raise that on appeal.
I know you're making the error, Your Honor.
Mr.
You wanna
Brooks,
explain
I'm
to
not
me
going to
why?
have a debate with you right now. We
I'm
are
not.
continuing on. I'm giving you the courtesy to respond to each one of these things. That's how I've responded. I expect that you will, even if you disagree with my decision, sir, that you will respect it and we'll move forward. The next piece of paper filed at 1:52
I still would
p.m.
like a judicial, are you making a
says,
judicial
are you making a
determination?
judicial determination? I'm not allow my right under the First Amendment to freedom of speech in this courtroom. Mr. Brooks, we have rules of decorum and courtesy. They have been provided to you multiple times. They are part of the materials that you have before you.
Do they fall under the First Amendment?
SCR Chapter 62 discusses just the standards of courtesy and decorum for the courts of Wisconsin. In addition, sir, parties are able to file requests with the court. It's called a motion. A motion, however, is based in law. There is a citation to not only that law, but relevant facts, and there's a request for relief. While you have the right to present a defense, you do not have a right to disrupt the proceedings.
That was not
And
disruption.
Mr. Brooks,
I was asking, will my First Amendment right, which is freedom of speech and the right to be heard in court, will that be honored by Your Honor? That's a valid question
Mr.
because
Brooks,
that's a constitutional
I
right.
have given you ample opportunity to present information, evidence, to question when we've had witnesses on the stand, but I expect you to follow the rules of procedure, the rules of evidence when presenting your requests.
I can't even
So-
get these admitted into evidence.
That's, Mr. Brooks, I cannot explain to you if you don't understand the basis in law for the denial.
You're right. I don't understand.
Not our
But
problem.
I was
But that
following-
doesn't mean we're going to have a
I was
discussion
following- no,
or a
I'm not
debate
trying to debate
about
with you,
what
but I
it
was
means, because we're
following-
not
I
going
was
to do
following
that.
the rules that you said.
So the bottom
by
line is, I
writing
don't
and
feel,
sending-
Mr. Brooks, stop talking. I do
No,
not
I was
feel,
right. I was following the rules when you said that I had to make all
and you did, and I'm
objections
going through
in
them, so
writing.
give me the courtesy of replying or responding to these. And please give me the courtesy that even when you disagree with how I answer them, that you will not interrupt me.
It's not about me trying to interrupt you, Your Honor.
Mr.
All I'm
Brooks,
saying is
I'm going to address the next one,
what
so
you-
please pay
what you
attention.
were saying about decorum. I was asking, does that fall under the First Amendment? Because the First Amendment, which is my constitutional right, says that I have the right to freedom of speech and to be heard in this court.
Mr.
That's
Brooks,
all I'm merely-
again, you have the right to present a defense, but that right is not unfettered.
But that's under
That
the Sixth
right,
Amendment. I'm
Mr.
talking
Brooks,
about the First
you
Amendment.
are interrupting me. Stop.
Because you're talking about
No,
a-
because you're
talking about an
purposely
amendment that I'm
doing
not
this,
referring
so
to,
I
Your Honor.
can't get my reasoning
But
out.
I'm
You
not
make it
referring to the
incredibly
Sixth
difficult.
Amendment. I'm not referring to the Sixth Amendment. I'm
Mr.
referring
Brooks,
to the First Amendment, which clearly says that I have the right to freedom of speech and to be heard in the courtroom. Are you not going to honor my constitutional right, Your Honor? If not, that is judicial misconduct, and you're making a judicial determination to not honor my constitutional right. I just want to be treated fairly, like anyone else, which you said on the record that you will be fair and impartial. What
Mr.
you're
Brooks,
doing
you
is
also
not
have
fair
an
and impartial.
obligation to treat this court fairly, and you have an obligation to follow the rules of courtesy and decorum, the rules of procedure, the rules of evidence.
Your Honor, I did
That's
not-
the playing field that you willingly entered into and made a deliberate
did not.
decision to waive your right to an attorney
I
and
can-
to appear
I
in this
consented-
case
I
as your own
consented
attorney.
to represent myself pro per. The same paperwork that you gave me, you have, and I also have a copy of the same one where I scratched out what I did not agree or consent to. We both know that, Your Honor.
All I'm
Mr. Brooks,
simply-
I made
all I'm-
findings regarding that, and those findings stand, that despite you scratching out some of those words on
But-
there, I
but
made
you-
very specific findings about your waiver of right to an attorney. So we're not going to relitigate that here right
You also
now.
accepted the terms of the paperwork that I
Mr.
filed out.
Brooks, I'm not going to engage with you about whether you and I have entered into some type of a contract
We did
or
not.
engage in
We did
any
not.
type of
We
that
did not
kind of
enter into
dialogue,
any
because
contract.
that's what you're claiming through some
No,
of
I'm
these
not.
filings,
I'm
and
not
you've
claiming
said that
I
previously.
am not claiming that, Your Honor.
So,
In any way, shape,
Mr.
or
Brooks,
form, I do
I'm
not
giving you
consent to
some
any
leeway.
contract.
You continue to talk over me. It's, you please, I'm asking you to follow the rules of civility. Simple rules, sir. Don't interrupt me.
Did I not just let you read the whole jury instructions and follow the rules that you said I have to write down
You did,
anything that I object to and then hand it in?
except
I'm
now
a-
that we're discussing them, it seems to me that the rules don't quite matter to you, sir.
No, that is not
Boom.
what's
So,
being asserted on
Here's
my
what's
end.
happening, sir.
All
I'm
I'm-
telling you,
all
I'm
I'm asking
advising
for-
you to respect the rules. I'm advising you that if you continue to interrupt, you risk forfeiting your right to be present in this courtroom.
Are you,
Because I still need to continue with these proceedings, sir. I need to go through all of the documents that you filed, and you're not letting me do that.
because we didn't
So
get
I'm
past
gonna,
the
if I
issue.
need to,
It's-
I'll remove you to the other courtroom so that I can do this.
This is,
And yes, exercise the mute button, sir.
this
But-
is,
And
this
then
is
I'll bring
something
you
that was
back when the
filed, though.
jury's back.
this was filed though, Your Honor, and it's a valid.
Mr. Brooks is
it's valid.
clearly not following the simple rule of civility that I have established.
That's
He
inaccurate,
continues
Your
to
Honor.
interrupt. He's not providing this court
inaccurate,
with
Your Honor.
ability to make rulings on the record without interruption. So this is your final warning, or you will be removed to the other courtroom.
Will Your Honor honor my First Amendment right?
Nope.
I'm
Or are
not
you
answering
making
that
it- or are
question,
you
sir,
making it
because
the-
I've already addressed
So
it.
you're making a judicial determination to deprive me of my constitutional
I am not
right.
making any such determination, sir.
So you just said you're not gonna answer the question about my First Amendment right, which says
Sir,
that
I've
I have
already
freedom of
answered the
speech.
question that you have a right to present a defense,
That is the
You have
Sixth
a right
Amendment,
to
not
be
the first.
present.
You're trying to
You
twist up the
have
amendments.
a right to present your defense, but your rights are not unfettered.
You trying to twist up the amendments.
Yes, they
your
are, Your Honor.
rights-
You're citing the Sixth Amendment, which I am not
Mr. Brooks,
questioning.
your
I'm-
First Amendment in some respects is circumscribed by the rules of evidence and the rules of procedure.
Does it say that I have
So that
freedom
doesn't
of
mean you
speech?
get to say anything that you want in
No,
front of
I'm-
a jury.
Your
And it
Honor,
doesn't mean you get to put forth any kind of evidence that you want in
Your
front
Honor,
of a
am
jury.
am I
What it
being-
means, sir,
am I
is
being
that you
disrespectful?
must
Am I
follow,
calling you
yes,
out
you're
your
being
name? Am I threatening
disrespectful because
anybody?
you're
I'm
not.
not doing anything of the sort.
All right, he is continuously talking over me. So at this point, I'm gonna find that he's forfeit his right to be
I have
present as
not
I
forfeited
go
my right,
through
Your Honor. I have
his-
not consented to any, I'm
his
simply trying to
paperwork. He's to be
understand
removed to the other courtroom
I'm
until
simply
such
trying to
time as he
understand
can pledge to
why we're
follow
not
the
talking
rules
about
of
the First
decorum and
Amendment. I'm not
civility.
talking about the
We'll be
Sixth
in
Amendment.
recess until we have
Your Honor, I
everything
do
set
not
up.
agree to a
The record
estoppel.
to reflect, I'm stepping off. The
God. Oh, 2 hours and 9 minutes so far. And that was on speed, y'all. That we were on fast speed. Let's see how many. And poor Zach's still waiting to make his opening statement. Let's see. It's 6 hours. 6 hours total that they've been there in the courtroom that day. And this is still going on. All right, let me see something. When he goes to do his openings, we're not gonna. Okay, we're almost done for the night, so bear with me, guys. Mm-mm-mm. Oh, I got it on normal.
the record should reflect that Mr. Brooks is now appearing from the other courtroom. Prior to the court taking the short break, the court was attempting to address the filings from Mr. Brooks that he made pursuant to my request.
Oh, now he's looking at his bruises
to
again.
write down if he had an objection. I have 5 different, what I will refer to as filings, one of which he provided to Deputy Wittig at 12:05. So that was right around the time we broke for lunch. A second one, 1:52 p.m. today's date, October 6th. And then there's another 1:58 p.m. October 6th, 2:03 p.m. October 6th, and then
Hello,
looks
stealing
like
my
the
old
time
friend.
is 14:28.
I come to stare at you again.
So 2:28. The other one was received. Mr. Brooks, I'm going to make a record first as to why you've been removed, and then I will hopefully get to the filings. I need you to not interrupt me at the moment. You are unmuted. But after the court completed the preliminary jury instructions and the reading that is to the jurors, I excused the jurors so that they could take a break, but also because I knew there were a number of what I will loosely refer to as objections that were raised by Mr. Brooks. I wanted to take an opportunity to address those first before moving on to opening statements. As I attempted to address those with Mr. Brooks, there was, from my observation and opinion, and I'll make a finding that it was pretty much a consistent talking over me by Mr. Brooks. I wasn't able to really go through any of these filings with any specificity. I attempted to go through the first one, which I did. I mean, I did tell him I wasn't going to address that. And then we were talking about his second one when really it kind of devolved from there. The record is very clear that Mr. Brooks has been advised on multiple occasions of my expectation regarding courtesy and decorum in this courtroom. I've referred to at many times that there's a very simple rule of civility I expect him to follow at a minimum, and that is to not interrupt. It shows a complete and utter lack of respect for the court process, the court proceedings. It interrupts the court as the court is attempting to make a record of what is happening and decisions that I am making. And after repeated warnings to him,
Welcome, Muffy. Thanks for becoming a member, honey.
the court made a determination that he had forfeited his right to be present in the courtroom while we discuss his filings. The record will reflect that Mr. Brooks did not give consent. I am still continuing with my findings, sir, so I'd ask that you not interrupt me. Mr. Brooks, I'm not done. I'm going to mute him because frankly, can be difficult to keep one's train of thought when you are consistently interrupted, which is why I believe he engages in the conduct that he does, because it's plain and simple. It is disruptive. It disrupts my thought process. It disrupts the proceedings. I was so pleased, Mr. Brooks, when you were able to follow the simple rules when the jury was here and I was going through the jury instructions. I know you had some objections. You wrote them all down. You followed that procedure. I told you I would take those up after I got through the jury instructions. I was attempting to do that, but then you started in with your antics, with your interruptions. It doesn't matter to this court if you're mild-mannered, if your tone of voice is a normal tone of voice, meaning it doesn't matter to me that you're not raising your voice, you're not making any threats or anything like that. That certainly would take things to the next level, in my opinion, but it's not necessary for this court to make a finding that your behavior is disruptive. And this obviously comes on the heels of your conduct this morning, where you spent the vast majority of the morning in the other courtroom based upon your conduct. And I'll once again rely on the decision in Illinois versus Allen, 397 U.S. 337, a U.S. Supreme Court case from 1970 on the options the court has constitutionally when faced with a disruptive defendant, someone like Mr. Brooks, who cannot conduct himself consistently with the decorum and respect that is inherent in the concept of courts and judicial proceedings. The consistent interruptions are not only disruptions, but it interferes with the proper administration of this trial. It disrupts the dignity, order, and decorum of this court. Those are the hallmarks of all court proceedings. I'll make a finding that he flagrantly disregards in the courtroom elementary standards of proper conduct by repeatedly interrupting this court. And therefore, he has forfeited his right to be present while we discuss all of these filings. I'll also make a finding that the technology that we are utilizing here today, we are Polycom to Polycom. The audio and video have been working very well this afternoon. No issues with that, and that it's the functional equivalent of Mr. Brooks being in this courtroom. It gives him the opportunity and the ability to meaningfully participate while the court is still able to control his behavior by exercising the mute button, as I have repeatedly throughout these proceedings. I believe all of the documents speak for themselves, I should say. But what I will do is go through them one by one from the beginning. Since they're Mr. Brooks's filings, his position has been made known. I'll ask the state to respond. If I feel any additional follow-up is needed from Mr. Brooks, I'll ask him for that, and then I'll make a decision. So even if that's backtracking a little bit, it's a little bit easier to do that with him in the other courtroom. So the first one that I will deal with is the one that's got today's date and 12:05. I addressed it earlier in terms of that I did not believe it was a filing that required any court response, and I'll ask the state if the state sees any of that differently.
No, Your Honor, and I would cite the court's United States versus Benabe, B-E-N-A-B-E, at 654 Fed 3rd 753. It's a Seventh Circuit case from 2011. Specifically, there's very instructive language on page 767. This case involved a defendant who identified himself as a sovereign citizen. The court goes into a nice discussion as to such claims having no merit whatsoever. The quote is, the proposed sovereign citizen defense has, quote, no conceivable validity in American law. I think that's applicable to several of these filings here, Your Honor, and I think that's relevant authority throughout the remainder of this trial, that these sovereign citizen defenses have been attempted. There's a lot of cases on this. That's the most recent from the Seventh Circuit that I could find. In no way have any of these defenses, such as his name, the jurisdiction of the court, the fact that the state's an entity, any of these efforts that Mr. Brooks has tried to put forth have been soundly rejected by the courts, and there's significant case law on point, but that's the most recent and appears to fit really well with the facts of this case.
I would note the documents he refers to in this particular piece of paper references the notice of special appearance, the statement of particulars, both are by affidavit. Those are two of the common sovereign tactics. And I believe Beneby, and the language that you cited is directly on point, and that is why I can simply deny the request to address those filings without any further discussion or hearing on them, even without giving Mr. Brooks an opportunity to further respond. The second statement, and I note he's raising the objection, and I'll indicate for the record he's objecting to what's being ruled upon. Then the second filing, we heard him discuss at length, so I'll just have the state respond to that, and that was his claim that his First Amendment rights to freedom of speech are not being honored in this courtroom.
So the court has been abundantly patient in allowing Mr. Brooks to make appropriate, relevant legal arguments. The court is 100% accurate that no constitutional rights is absolute, and there is, they can be fettered under appropriate situations, and you've made an excellent record as to why that is appropriate in this case.
Mr. Brooks is raising his objection sign. Since he was given an opportunity to address this previously, I'm not going to give him further opportunity and simply indicate that he will be allowed at appropriate times under the rules of evidence, under the, to present his defense. It appears to me at times he may confuse the ability to file something into the record with the ability to present evidence. We have yet to start the evidentiary phase of this trial. In addition, any of his specific objections should be brought by motion. Even if that's an oral motion, it should be based in law and fact and request specific relief. His filings make claims that have no underpinning in law or fact. It's really conclusory. This court is under obligation to address, conclusory statements by him that are not properly made, both in form and in substance. This record's replete with references and instances of Mr. Brooks just simply spouting various amendments or theories without those fully being established in the record. And again, no constitutional right is absolute. The First Amendment rights of an individual can certainly be fettered. That is especially true in a court of law where there are rules of evidence, rules of procedure, where we have the standards of courtesy and decorum. He can present his defense. He has a right to present a defense, but his rights to do that must comport with the law. And that law is what I've already pointed out. So I'm not sure really how to address, are you making a judicial determination? Everything that I do when I rule on something is a decision that is made by this court. So I've answered this. We'll move on to the next one. That is and he is raising his objection, and that's fine. He can do that. His objection will be noted for the record. He also raises in the next filing at 158, I still motion to prove jurisdiction, please. Also motion to dismiss for no proof of jurisdiction. Also motion for finding of fact. Again, none of these things cite to any legal authority or any factual basis, nor do they request any specific relief. Here's what I will rely upon the Beneby decision from the Seventh Circuit, that these are just various arguments raised by sovereigns that have been debunked and have been addressed that have no place in our justice system. And therefore, I will deny the requests in that piece of paper summarily without further consideration. I know he makes repeated objection to either how I say his name or how it's referenced in the caption. There's a continuing objection that I will note. His filings speak for themselves, how he wishes to be addressed.
This court will refer to the name that is on the information in this case. That is the official charging document. And that is what I will do. If I mispronounce his first name at times, my apologies. I know I said it, his name repeatedly throughout those jury instructions. I know when I first had hearings on this case, even his own attorneys referred to him as Darrell. It was only after I viewed his recorded interview that I learned it was Darrell. I asked him at one hearing, how do I say your name? Is it Darrell? And he said, that's right, or words to that effect. I may not have the exact quote, and I'm not quoting him, but he confirmed for me on the record, at least at that point, what his first name was. So his continuing objection about his name is so noted. It's preserved in the record based upon his filings, and I'm not going to address it further. Frankly, his last document, which says a plea is to argue facts. I don't intend to do that, and I never agreed to or consented to a quote, not guilty, quote, plea. My attorneys never got my consent for a not guilty plea. I don't understand. The law is very clear that a plea of not guilty, even when a defendant stands mute, is what the court proceeds with. It is true in this particular case that plea was entered on his behalf, but the fact also remains that in order for that plea to be changed to something else, meaning a guilty plea or a no contest plea, the defendant would need to go through the plea questionnaire waiver of rights form and have to knowingly, freely, voluntarily, and intelligently waive all of the rights that go along with that. In other words, this court is simply constrained by the law to proceed as if not guilty pleas were entered on his behalf. So I've addressed that. I don't need any further argument from the parties. I will note Mr. Brooks continues to have the objection sign raised. The other thing I want to make a record of, we did have the civilian jury bailiffs check with the juror that was identified by Mr. Brooks, and that juror confirmed she has not attended any proceedings. So that issue is addressed now. He's holding up his objection sign. Mr. Brooks, you know, I frankly did that for your benefit. You raised what really is an important issue, and I appreciate that. I was a little surprised by it, but then when I heard you explain further, I thought, you know, he's got a point there. He had been removed for some of those proceedings. You may not have seen her. I'm not making a finding on that. And so that's why I backtracked a little bit, said I would look into it. So I'm not sure why you're objecting at this point. I took an important piece of information that you were relaying, and we had it, in this case, it was confirmed that the juror did not attend any proceedings, and so that will address your issue with her. All right, now the next step would be opening statements. So, Mr. Brooks, you have demonstrated in the past, and I'm going to unmute you, that when the jury is present, you are able to maintain civility, show them respect, show the courts and the process respect and dignity. I certainly am willing to have you brought back over while the state gives their opening statement, and certainly if you choose to make an opening statement, for you to do that in this courtroom in the presence of the jury. I know you're holding up your objection sign, sir, but I am giving you the opportunity to come back over here. Would you like to come back to this courtroom? Record should reflect he's holding up his objection sign. It appears that he's writing, I don't know what, of course. Mr. Brooks, I'm going to ask you again. Would you like to come back to this courtroom for opening statements?
A little higher on the objection sign, Louise.
So I'm on the record.
You are. If you would please address my question.
So you want me to come back over there just to get brought back over here?
That's not what I asked you, sir.
I told you, I advised you, I would like you back here. It's always my preference that you're here. You demonstrated previously that you can follow some rules when the jury is present. The jury is going to be brought back in shortly for opening statements. The state will go first as they bear the burden of proof, and then you will be given an opportunity to also present an opening statement. So my
I
question
sure-
to you is, do you want to come back to this courtroom, sir?
So I can get sent back over here, because as soon as I say something, I'm gonna get sent out.
Mr. Brooks, it's your conduct in this courtroom. It is what dictates the court's response. If you follow the rules of decorum and courtesy and civility, you will remain. But if you choose to
You're
not
saying
do that, then you run the risk of once again forfeiting your right to be present.
You say that even though I never consented to being taken out. You say that everything is about the decorum and all this. That's what you say. But when I'm raising issues of understanding, which I keep telling you I don't understand, then it's looked at as being disruptive. It's looked at as intentionally trying to be disruptive. And I don't understand why everything I say has to have some type of disruption title to it. It's even been put on record numerous times with inaccuracy. Even what happened today, nobody reported on record about me being bruised up and having to get bandaged up and all these things, but it was put on me, laid at my feet, as if me, quote unquote, being disruptive was deserving of what happened to me. I'm simply trying to have a fair trial. And if I don't, forgive me for being this way, Your Honor, but if I don't understand, I'm going to ask
This
questions.
way.
That's the only way I can have clarity, is by asking questions. And you have refused to answer anything, but I have to answer everything you ask me. Where's the give and take? It should be fair. I'm not asking for legal advice. I'm not asking
Yeah, you are.
for nothing like that. I'm asking to simply have clarification so that I can understand. I cannot put on an adequate defense if I don't understand something. Do you see these boxes I got right here? Do you think I was able to go through everything in those
Mr.
boxes?
Brooks, I'm not going to go through this with you again, where you attempt to put on the record all of these issues that you have when we're in the middle of a trial. All right. You willingly waived your right to an attorney. I made all of those findings, so we will go
You
forward.
made those findings,
I
but
am not obligated to answer questions.
made
When you
those
ask me
filings.
questions, I'm going to mute him.
Yeah.
I am not obligated to answer questions that explain procedure or the law. I am obligated to address motions to address that are based in law and fact. I'm obligated to address objections, for example, whether it be to testimony or evidence or questions posed to witnesses. But I'm not obligated, sir, to provide you with an explanation of the law, of the procedure. And with that, since I gave him two opportunities to answer a very direct question, and that was, do you want to come back to this courtroom? And he chose not to answer it, but instead ask a question and then start making statements about his lack of understanding. I will find that his non-response, that he has not answered directly, which to me says he's not willing to follow the rules of decorum and courtesy and civility, and without such a pledge, he will remain in that courtroom. He's muted. The record should reflect. It appears he's talking as well. He's making hand gestures. His lips are moving behind the mask. And I just wanted to make a record of that. All right, then we will have the jurors brought in, and then the state can then proceed with its opening statement.
Oh. Whew. You guys, I gotta call it. gotta call it. Before I call it, though, I want to go over some of these little things that you guys have said here. Again, want to thank Lynn Cordova for becoming a new member. Mark's been a member for 2 months. Want to thank Miss Janice for her super chat. Thank you, honey. I appreciate you. Uh, I want to thank Crazy KC and Mark both for gifting memberships. You guys are awesome. Thank you, Mo, for your super chat. And Lori Pavic. Lori, I know I just butchered your last name. I apologize. Thank you for your super chat. Let's see. Couple of things here. The freaking Pope on our channel cracks me up. He says, unless the freaking Pope's a woman, but it says, reminds me of when he thought not going to the vehicle view meant they couldn't have one. I know, right? Like, he's like, no, I don't agree with doing that. So they're just, okay. So, oh, you don't, okay. We didn't know you didn't want to go. We'll just cut that out of it. We'll take that out of the trial. Let me just scratch that out real quick. Okay. Louise says, I'm sure he was given a bag of blood during the break. So he had to have a blood transfusion during the break for his pink finger. That's a good one, Louise. Kauai says, I can't wait for his appeals attorney to find nothing. Pop J says, the fact that she's not gagging him was special treatment. Preach. Zephyr said he heard every damn word she said, and y'all know it. Jason says, I want to see the rejection letters Duhan is getting. Oh, you're talking about Darrell. Is getting apparently. Oh, no, Dawn. Just getting, apparently she's been writing every politician she can find. Yeah, that's about sick. You can tell he's spent his life getting away with all this behavior, says J. Carr. Laura says, but you're wrong, Carrie. Remember, nobody can bring a claim against him. So there is no case, and no one in the courtroom has filed any complaints against him, so he's done nothing wrong. Preach. Right. Louise says, not fair. She only gave me 3 tries to answer that question. Condi's back in the house. He said, glad they put him in shackles and require him to sit his behind down. Pop J says, you never heard the statement, if you're feeling froggy, then jump up. Oh, yeah, that's right. Tiffany said that. I've never heard that. I've never heard froggy. It's not a thing here in Alabama. We go frog gigging, but I've never been froggy. That's what they do here. Okay. He is a troll under a bridge, said Casey. Tony says when she talks him up, he's schmoozing him. Yeah. He thinks she's like being flirty and all that. Sickening. She's just getting it on the record, and she's doing what's right. My cat could take Darrell. I know, right, Cher? These bailiffs could stomp the crap out of him if they wanted to, said Lori. I know. Lori also said that Darrell was an elf on the shelf. John Bubba says Darnisha is an elf on the shelf at Dodge. Tony says, bet her experience as a mom with small children really came into play when dealing with the childish behavior of Brooks. You know it. Because there's not anybody that could have put up with that. I couldn't have done it. I could not have done it. And I know there's a lot of you out there that said I could not have dealt with him. Mark says, I'll remind everyone again, don't forget to send Xmas cards to Darrell. She has a twin sister. Oh, yeah. Zephyr was telling, y'all were talking about Judge Darrell in the chat and her kids and everything. She has a twin sister. Jojo says, thank you to whoever gifted me a membership. Jojo, I don't know who gifted you one, but I've named a couple of people here today. I want to thank Muffy for becoming a member. And Coffee Cake says, if I recall, the DA's office got inundated with emails about Darrell's mental condition. What kind of emails? You mean like emails saying he's not mentally capable of representing himself? Susan B says, I wish we could afford as a group to get this man's jail calls. Some of them anyway. Susan B, they're not available. I've gone after them. I can't get them. So it's not a matter of paying for them. It's just that they're not. I think they might be available. I think there might be some available after this trial with Erica. I'm not sure though. Cass says she's not getting notifications, and I think Blanco was having problems with that too. You guys, I'm putting a link in the chat if you're not getting notifications, my channel, anybody's channel, click on this link. I looked it up after our last stream, and I was just going to see if it was helpful to anybody. Maybe it'll help. Hopefully it'll help. I don't know. So I just dropped that in the chat. Joe Bubba said we were talking about the judge getting pickup for her wine bottle every day. Yeah, she probably didn't get curbside delivery. I would, if I wasn't a drinker, I would become a drinker. You know. Marcus says it seems like every time I watch his trial, I always notice something I've never noticed before. Marcus, are you with Stephanie, that old girl? I'm just I'm asking for a friend. Y'all think he is going to delay again on the 14th? No, Maya, I don't think he is. I think he's already got his attorney. So I don't know if I don't know if they'll stream anything, but we're going to be there just in case they do. Tara was asking me about having the chat run in the screen. Tara, that is something that is done with the software we use to go live. And I use StreamYard, and StreamYard does not have that feature. So when you're watching my chat or whatever, it's only on the side of the screen. So you can't be in full screen on your computer. You have to have it, and the chat will come over on the right, or you could pop the chat out on its own. But I know it's you can't see it if you're on TV. So some people have to get on a phone. Sorry. I'm sorry. Let's see. Now I want a slice of law berry pie. I'm not a big berry pie person, but a law berry pie might be worth checking out. That was from John Bubba. Of course it was. Budgie Girl says, "Oh, the juror flipped me off trick." Well, it was like, okay, that didn't work. So let's try the jury thing. Okay, now if that doesn't work, okay, oh, we'll go COVID. I mean, it's just like the tricks that he pulls. And oh, I don't understand. I don't understand. How can I answer you when I don't understand? I mean, that's his major go-to when all else fails. I haven't enjoyed adult relations since the Carter administration, but please, someone explain to me who would have sex with this man. Cass, that is probably the best thing you have ever said. I don't understand it either. I don't understand it. He goes after young women that are impressionable, so that probably says something for it. John Bubba says $50 per shock. All funds go to survivors and memorial funds. DB would be glowing like a Christmas tree and smoking like a brisket. I'm sorry, Yaki said that too, John Bubba. You guys are so funny. I'm so in love with all the Brooksaholics here. Yes, Super Kelly, I am too. Cher said, Carrie, did you find the second interview on Dawn? Okay, so I just made a note, Cher, to go and look for some more interviews after the trial because I don't know. I haven't found any, and I haven't even looked. So that's on my to-do list. Cass wants to know what the Hiki and the Kiki Club is. You're already part of it. You became a member of my channel. You become a member of my channel, then you become a member of the Hiki and the Kiki Club. If you're not a member, you're just a Brooksaholics. You're just an addict. I love you guys. All right, so next stream is not going to be tomorrow. I'm going to have a stream tomorrow, but we're going to be streaming. We're going back to the Halderson trial. Got some stuff to go over with that one. It's going to get good, you guys, because tomorrow we're watching the testimony of the mom's girlfriend, where was the location of where he left part of the remains. So tomorrow's a big day to watch. So if you can come on in the morning, I think I got it set for around 11 a.m. And then did I set one for tomorrow afternoon? I don't think I did. If I did, then I'm coming back. I don't know. I guess I did set one. I forget. I'm getting old, you guys. I forget what I do. Anyway, there's going to be another one. I've already set it up. We're going to do day 2, 3, and 4 of the morning sessions with Brooks the next time up. So please come back and see me later. And thank y'all for joining me tonight. And if you don't mind, if you enjoyed being here, which you would please hit that like, that helps me tremendously. If you leave a comment in the chat, that helps even more. And I just appreciate you all. Y'all have a blessed evening, and I will talk to you very, very soon. Good night.